You can discuss as needed as well. So I have left copies of the jury instructions. I believe they're updated from this meeting.
Okay, yeah, it looks like it. Thank you. Hang out. Just gotta stay close. You can. But they'll tell us.
Seated, please. We are on the record, counsel and parties are present. The jury is not present. Just wanted to see if there was anything else we needed to discuss or any other issues with the jury instructions before we brought the jury in and instructed them.
No, Your Honor.
No, Your Honor.
Okay, let's bring the jury in, please. Yes. Be seated, everyone. We are on the record. The record will show that counsel and the parties and the jury are all present. Folks, we are ready for the reading of the final jury instructions, and then we'll hear closing arguments from the lawyers. You've heard all the evidence that you're going to hear, and now it's time for closings. There were some jury questions that I'm not able to ask, and so we'll move directly into the reading of the final jury instructions. You've got copies of those. You can read along with me if you wish, or just listen to me. You'll have these with you throughout deliberations. Duty of jury. Now that the evidence has been presented, I'll give you final jury instructions. That with the preliminary jury instructions govern your deliberations. Burden of proof. Burden of proof means burden of persuasion. Unless otherwise specified in these instructions, the party who has the burden of proof on a claim or issue must persuade you by the evidence that the claim is more probably true than not true. This means that the evidence favoring that party outweighs the opposing evidence. In determining whether a party has met this burden, consider all the evidence that bears on that claim regardless of which party produced it. Some of the claims in this case require proof by clear and convincing evidence. A party who has the burden of proof by clear and convincing evidence must persuade you by the evidence that the claim is highly probable. This standard is more exacting than the standard of more probably true than not true, but it is less exacting than the standard of proof beyond a reasonable doubt. Use the standard of more probably true than not true for all claims in this case, except for those on which you are specifically instructed that the burden of proof is clear and convincing evidence. Plaintiff's breach of contract claim. Plaintiff Zubair Hussaini claims that defendant Ioana Samartinian breached a contract and seeks damages for the breach. To prevail on a claim for breach of contract, a party must prove 1, there was a contract with the other party. 2, that the other party breached the contract. And 3, that the breach resulted in damage. Contract definition. A contract is an agreement between 2 or more persons. For a contract to exist, there must be an offer, acceptance of the offer, consideration, and terms sufficiently specific so that the obligations created by the contract can be determined. An offer is a proposal to enter into a contract on the terms contained in the offer, and acceptance is an expression of agreement to the terms of the offer by the person to whom the offer was made. Consideration is a benefit received or something given up or exchanged as agreed between the parties. Good faith and fair dealing. A party to a contract has a duty to act fairly and in good faith. This duty is implied by law and need not be in writing. The duty requires that neither party do anything that prevents the other party from receiving the benefits of their agreement. If you find that a party has breached the duty of good faith and fair dealing, the other party is entitled to recover damages proven by the evidence to have resulted naturally and directly from the breach. Modification of contract. After parties enter into a contract, they may agree to change it. The party claiming there has been a change must prove that there was an offer to change the contract, acceptance of that offer, and consideration for the change. Waiver. A party to a contract, excuse me, a party to a contract may waive the other party's duty to perform. Performance refers to what a party agreed to do as part of their contract. Waiver is either the express, voluntary, and intentional relinquishment of a known right, or it is conduct that is inconsistent with an intent to assert that right. By accepting performance known to be deficient, a party has waived the right to reject the contract on the basis of that performance. If a party has waived a promised performance, then the other party is no longer bound to perform on that promise. A party claiming waiver has the burden of proving it. Breach of contract damages. If you find one party is liable to the other for breach of contract, you must decide the full amount of money that will reasonably and fairly compensate that party for the damages proven by the evidence to have resulted naturally and directly from the breach of contract. The damages you award for breach of contract must be the amount of money that will place the non-breaching party in the position they would have been in if the contract had been performed. To determine those damages, you should consider the following. 1, the profit a party would have received had the contract been performed. 2, the return of the value of the things or services that one party provided to the other. 3, the value of things or services expended in preparing to perform his part or her part of the contract, or in preparing to accept the benefits of expected performance. Whether a party, by not having to perform their part of the contract, has avoided any cost or loss which should be deducted from their damages. Determining intent of the parties. In deciding what a contract provision means, you should attempt to determine what the parties intended at the time the contract was formed. You may consider the surrounding facts and circumstances that you find them to have been at that time that the contract was formed. It's for you to determine what those surrounding facts and circumstances were. To determine what the parties intended the terms of a contract to mean, you may consider the language of a written agreement, the acts and statements of the party themselves before any dispute arose, the parties' negotiations, any prior dealings between the parties, any reasonable expectations the party may have had as the result of the promises or conduct of the other party, and any other evidence that sheds light on the party's intent. Defendant's conversion claim. Defendant Samartanian claims that plaintiff Hussaini committed conversion. Conversion is the intentional exercise of dominion or control over property, which so seriously interferes with the right of another to control it that the actor may justly be required to pay the other the full value of the property. If the elements of conversion are shown, then you must consider the seriousness of the interference and whether Hussaini must pay full value. Defendant's breach of fiduciary duty claim. Defendant Samartanian claims that plaintiff Hussaini was a trustee and breached a fiduciary duty owed to her. Trustees owe a special duty to the beneficiaries of trusts, which is called a fiduciary duty. This duty requires trustees to act as reasonable persons and or use their special skills or expertise in dealing with the property of others. To establish this claim, Sammartinian must prove, number one, Hussaini breached this duty. Two, Hussaini's breach was a cause of Sammartinian's damages. And three, Sammartinian's damages. Before you can find Hussaini liable on the breach of fiduciary duty claim, you must find that Hussaini's breach of fiduciary duty was a cause of Sammartinian's damages. A breach of fiduciary duty is a cause of damages if it helps produce the damages and if the damages would not have occurred without the breach. If you find that Hussaini is liable to Sammartinian on the breach of fiduciary duty claim, you must then decide the full amount of money that will reasonably and fairly compensate Sammartinian for any of the following elements of damages proven by the evidence to have resulted from Hussaini's breach of this duty. One, loss of money or other property. Two, the profits or proceeds that Sammartinian would have received had Hussaini performed his duties. Three, money or property that is unjust for Hussaini to keep. Defendant's fraud claim. Defendant Sammartinian claims that plaintiff Hussaini defrauded her. To establish this claim, Sammartinian must prove by clear and convincing evidence, one, Hussaini made a representation to Sammartinian. Two, the representation was false. Three, the representation was material, which means that it was sufficiently important to influence a reasonable person's actions. Four, Hussaini knew that the representation was false. Five, Hussaini intended that Sammartinian would act upon the representation in the manner reasonably contemplated by Hussaini. Six, Sammartinian did not know that the representation was false. Seven, Sammartinian relied on the truth of the representation. Eight, Sammartinian's reliance was reasonable and justified under the circumstances. And nine, as a result, Sammartinian was damaged. The rest is a closing instruction I will give you after closing arguments. And with that, we'll turn the floor over to Mr. Handel.
Your Honor, may I approach the podium?
Yes.
No, putting that up on the board. It's okay. I don't need it for a minute. Your Honor, staff. Of course, I thank all of you for this opportunity to come here today and tell you our case. But in particular, jury, I want to thank you for your service. And there could be many reasons to be thankful, but I want to give you one in particular. You spent the last 2.5 days of your time, your attention to the case. Felt like 2.5 weeks as opposed to 2.5 days. However, in exchange for your time, which you will never get back, you build the system of justice. And many people believe that, system of justice is like a castle with thick walls. But in fact, it is more like a sand castle, and it's rebuilt each and every week by jurors like yourselves who come into the pool, elected, and then participate in this process. And so for that important reason, for a democracy, I certainly do express my thanks to you. So probably. Now, having said that, I understand you will follow Judge Warner's instructions, and I'm going to be actually fairly brief about what our perspective is on this case. In terms of the evidence, if you think about it, you spent the last 2.5 days looking at some documents and then listening to testimony. If you were to sort of put them into two buckets, the documents, to read them all wouldn't take too long, perhaps not all the text messages, but if you were to look at the documents themselves, they could be read through. But the testimony, what you've spent the last 2.5 days, more or less, listening to it, 95% of the time. And certainly the testimony has been about the documents, but if you were to have two buckets, read those documents fairly quickly, but you were listening to testimony most of the time. And when you talk about testimony, you are essentially talking about many things, what the acts of the people did, they say they did, and certainly their acts. But when you think about testimony, pay attention to the credibility of the declarant, of the witness, of the person who's speaking. And when you look at credibility, one of the factors in understanding what they're saying is true is their motivation. Motive makes a difference in life. For example, you could have two people with a cutting instrument cutting things. One is a surgeon. Their motivation is to help. Maybe one is somebody else with a less positive motivation. So motivation matters. In this case, you essentially had two different sets of motivations. And I'm not saying that they're entirely in separate buckets. Oftentimes motives get mixed. In this case, and also as is the case in life itself. In this case, the two motivating factors in our perspective is essentially love, one motivation, and money, different motivation. Not perfectly separated, sometimes combined, usually not to a good effect. Consider who is acting out of the motivation, however naive at times, of love, who's acting with a motivation primarily, predominantly for money. The documents, if you look at them, actual 5% of the case, look at the documents, which are real and important. But if you look at them, what explains their construction? All of the documents in this case, for the most part, ultimately had the effect of transferring Zubair's investment proceeds into the pockets of the defendant. It was a web of paper that lured him into a significant problem. Now, in terms of how you evaluate the evidence, different standards for our particular causes of action. It is the preponderance of the evidence. So we have the contract claims. Preponderance of the evidence means what is, in one way of framing it, and you should listen to Judge Warner, not me, and jury instructions, but what is more likely than not to be true? I offer to you that it is more likely than true, it's more likely than not to be true that there was a contract that began in 2017, 16, 17, continued over 5 years, and stopped in 2022, that the contract was breached by the defendant, and that Zubair's damages in total are $167,000. How do we calculate that? Refer up to this demonstrative exhibit. According to the testimony that we've heard, it was a total of $400,000 in an account. That was its ending balance in 2022, 23. 94,000 of it belonged to Zubair. It was his initial investment in 2017. The defendant invested the proceeds of the sale of the house of $175,000. You can subtract those two. Zubair has testified that he borrowed from credit cards, online loans, and cashing out his 401k, but the interest on those cards was about $15,000 when you add it all up. Thus, what was left over was $116,000 in profits. Dividing that per their agreement from 2017 in half yields $58,000, and that's his share of the profits. So when you add up the total damages of his original investment from 2017, $94,000, interest costs of $15,000, and then his profits of $58,000, the total yields $167,000. Having said that, and I'm not going to belabor your time anymore, it's simply this. Zubair, for his part, has learned certainly many lessons in this case, painful lessons. But the lessons of this case, which have left him with literally nothing, cannot be merely one-sided. Defendant breached her promises to Zubair, hold her to account, and find in favor of Zubair in the amount of $167,000 in damages. Thank you.
Thank you. Mr. Richardson, you're open, or sorry, you're closing.
Never mind.
Ladies and gentlemen of the jury, thank you so much. Like Mr. Hannell expressed, thank you for your participation in this process. It sure is memorable. I remember fresh out of high school, I got a jury summons and was selected to participate in a jury. That was more than 25 years ago. But something I will always remember, as I'm sure you'll always remember, the story of this case. Joanna and Zubair met in high school. They started a friendship, developed in college, and extended beyond graduation. We've heard those facts before. They became roommates in 2015, began investing together in 2017. Money doubled. They built tiny houses in the backyard. They took the equity out of Joanna's house and used it to invest in even more. Zubair even built the kitchen and bathroom for Joanna's tiny house. You may remember 2 M's and roommate. You may never forget that. You'll also remember that for Joanna, this was about being friends and making money. For Zubair, this was an effort to get closer to Joanna, to be her genie, to grant her wishes. For Zubair, there were possibly no lines that he wouldn't cross. He repeatedly signed agreements that he said were fake. Joanna did not think they were fake. She thought they were real. She complied with them. She lived up to them. What was the result? Well, she lost her house, the mothership. Now also has a second mortgage on the property, something she'd never agreed to. Words have meaning. Promises matter. Zubair testified that he had reassured Joanna that her ownership interest in the property did not change. But he didn't actually mean it. He meant something different, or entirely different. He said he didn't mean what the paper says. He meant that she could buy her house back at a later date. According to Zubair's own testimony, the owner of the property is Joanna. If you think about it logically, that's the only result that makes sense. Zubair testified that the 2020 deal was intact for years. Didn't fall apart until March 2023. Zubair also testified that the only way you could consider that Joanna paid on the 2020 agreement is if you count the rent as her money, which Joanna did. If you follow the chain of reasoning, it leads to only one logical conclusion, which is that if the deal was intact, it meant that she was paying half the mortgage through her niece's rent. And if she was paying through her niece's rent, then that means the rent belonged to her. As Zubair also testified, rent belongs to the owner, and since rent belonged to Joanna, that meant Joanna was also the owner of the house. That is the logical conclusion of his testimony. Even though he denied that she was the owner, you add it all together, it reveals the truth that Joanna has been the true owner all along. But just as you remember the story of this case and the evidence, I would also invite you and strongly suggest that you remember the court's instructions in this case. You'll have them with you, so it won't be any problem. But there are a few things that I want to discuss with you before we move on. First is, what is a contract? We already read the court's instructions regarding what comprises a contract, but I want to give you some examples. So contracts in the state of Arizona consist of 3 elements: an offer, an acceptance, and consideration. For example, if I go to a store, the price tag is the offer. I can accept that price, and if I give the store money, they'll give me the item. The price tag is the offer, me agreeing to pay is the acceptance, and the exchange is the money and the item. In this case, we looked at a lot of different contracts, and it's your job to determine if each of these elements, offer, acceptance, and consideration, were present with each one. The first agreement that the parties entered into wasn't really one we talked about a whole lot, but it was a lease agreement between Joanna to Zubair to rent her spare room for $380 per month. Zubair accepted the price, he paid the rent and moved in. Offer, acceptance, consideration. The next agreement that the parties entered into was an investment agreement in which Zubair offered to put up the money, $94,000, if Joanna would execute the loans. Joanna accepted the offer and began executing trades. And in exchange, each party would receive an equal share of the profits. Offer of 94,000, acceptance of the task, and consideration, the split of the profits. Shortly after this agreement, the arrangement changed. Parties may have had their own reasons for doing that. What matters is whether there was an offer, an acceptance, and consideration. So according to Zubair offered then to pay Joanna the 94,000 if she would provide him with 25 years of free rent. Joanna agreed. Offer acceptance. And the parties memorialized their agreement in a writing they called the residence agreement. Joanna stopped charging Zubair rent. He gave up the 94,000. Offer, acceptance, consideration. Then, yet again, in June of 2017, the parties changed the arrangement. Again, the reasons for that change are less important than the elements that are present. Joanna told you that the reason for the change was that Zubair changed his mind and wanted to have the money paid back and continue to receive free rent. Joanna accepted these terms and agreed to pay $3,500 per year, which she continued to do through 2025. Now, there's been a lot of hay made about whether this was fair to Zubair. But like they said, what was he doing this for? He's doing it for love. You love somebody, you give them sweetheart deals, you give them good terms. And that's what happened here. But the parties memorialized this agreement in the roommate agreement. We remember the 1M, which Zubair primarily wrote, and this agreement by its terms superseded all the previous agreements, written or oral, that the parties entered into. The roommate agreement turned the 94,000 back into a loan, which Joanna was given 50 years to repay. It also eliminated all profit sharing on the $94,000 investment money. Admittedly, this agreement on its face is highly favorable to Joanna, but does that make it less valid? No, not if we have all the elements. Is there an offer? Yes. Is there an acceptance? Yes, you saw both their signatures on every page of that agreement. Is there consideration? Yes. Zubair got a stream of payments and free rent for up to 25 years and a locked-in monthly rate thereafter. Joanna got to keep the investment money. That's consideration. Now, that's the end of the $94,000 agreements being changed back and forth. But it was not the end of the dealings of the parties. They continued to live together. We heard about the tiny houses, Zubair building the kitchen and the bathroom in Joanna's tiny house. And in 2020, the parties entered into a new investment agreement, now involving new money. It was the same parties and had to do with investing, but the terms and obligations were different and involved different seed money, this time provided by the equity in Joanna's house. In the 2020 agreement, Joanna agreed to cash out the equity in her home in order to fund a new round of investments that Zubair would guide. And in exchange, the parties would split the cost of the mortgage and the profits from the investment. Is there an offer? Joanna offering to cash out her equity. Is there an acceptance? Yes. Zubair agreed to help her get the equity and guide the investments. Is there consideration? Yes. The parties would contribute an equal share of the costs and receive an equal share of the profits. Now, this agreement had one other condition or term that was in order to extract the equity from Joanna's house, Zubair would have to be placed on the title of the mothership. However, he agreed that this was just to allow them to extract that equity and that the ownership interest would not change. Zubair affirmed this condition in writing in 2022. You saw that on the green graph paper, which he signed. He testified multiple times that he signed the ownership agreement in order to reassure Joanna. So ask yourself, is that how you reassure someone of a promise you made to them? By putting something different in writing than what you mean, what you actually intend. So, what contracts still remain? Well, there are only two. The roommate agreement superseded all prior agreements, including the initial lease agreement, the investment agreement, and the residence agreement. And the 2020 investment agreement also remains. Plaintiff wants you to think that all the written agreements were fake. He's told us for lots of reasons why he never intended to be bound by any of these agreements. He told you that on no less than 7 occasions, he signed an agreement in which he now says that the expressly written language of that agreement was not what he intended. In many cases, he intended the opposite of what the agreement stated. Plaintiff admitted that he doesn't even know what agreements are valid. He can't remember anymore which signatures were real and which were faked. He said, that's up to the court to decide. That's up to the jury to decide. It is. It's up to you. But can you trust somebody like that? Is that how a forever friend behaves? Do they pile up fake agreements with you, and then when the friendship sours, throw all of that away? Of course not. Plaintiff also wants you to believe that you want to breach these agreements. In order to show a breach of contract, the bearer must show that there was a contract, offer, acceptance, and consideration, and that a material term was breached by Ioana, and that breach resulted in damages to him. Certainly, there have been many contracts between the parties, but which contract do they contend was breached? They go all the way back to the 2017 oral investment agreement. There is no way that Ioana could breach the oral agreement because it was superseded on June 7th, 2017 by the roommate agreement. She agreed to pay the stream of annual payments, which she continues to do to this day. All right, so now let's look at Ioana's claims. The first is common law fraud. There's 9 elements of common law fraud. And I want to get through these quickly because I know after lunch, your bellies are full and you're ready to take a nap. But it's important to understand how this operates because we have a higher burden of persuasion on this claim. The first element is that Zubair made a representation to Ioana. We make representations all the time. You've heard dozens of examples of representations over the last couple of days. Zubair represented to Ioana that they could make money. He represented that he was a vegan, that he would grant Ioana 3 wishes. The representations we're concerned with in this matter, however, are the ones that led to the 2020 investment agreement. In particular, we're concerned about the representation that led to Ioana and her mother signing title of the mothership over to Zubair, which is that the true ownership interest would not change. Zubair represented to Ioana and her mother that the true ownership interest would never change, or would not change. The second element of this claim is that representation was false. Zubair told you that he did not intend to be a trustee of the property, he intended to own the property. He told you that the 2022 affirmation of the 2020 agreement was also not what he intended. He only signed that affirmation so that Ioana would not be upset. The third element is that the representation was material. What does material mean? It means that it's important to the parties. And important enough to influence Ioana's actions. You heard Ioana say that the only reason she agreed to sign over title to the mothership was because Zubair told her that she'd still be the owner and his name would just be on the paper. Element number four is that Zubair knew the representation was false. You heard him admit that he knew it was false when he made that representation. His explanation was that he was dumb. I did a lot of dumb things. The fifth element was that Zubair intended that Ioana would act upon the representation in the manner reasonably contemplated by Zubair. That's a long way of saying that he wanted her to agree. Did Ioana sign the house over to him? She sure did. He signed the title. The sixth element is that Ioana did not know that the representation was false. Now, Ioana said that she would not have done this deal if she knew that Zubair was going to assert ownership over the mothership. And we saw lots of text messages going back and forth, emails, where she was quite upset that he was asserting ownership of the house, that he was even going to try and fix the garage. Because in her mind, that was him exerting more ownership interest than he had. Just 3 more to go. The element number 7, Ioana relied on the truth of the representation, and she did act in reliance. You heard her testify that she relied on his testimony or on his statements. when she signed over the house and invested the money. Number 8 is that Ioana's reliance was reasonable and justified under the circumstances. What are the circumstances here? She had a long-standing relationship with Zubair. They'd shared a property together. They were roommates. They built tiny houses together. They'd known each other for many years. They had a history of making money off of their investments, so it was reasonable and justified that she would rely on his representation. The final element is damages. That Ioana was damaged by Zubair's false representation, which she relied on. And in this case, she was damaged. The loss is the title of the mothership, as well as a $115,000 second mortgage or deed of trust that now encumbers the property. She did not consent to that second deed of trust. Now, this is hardly the only time that Zubair made false representations that resulted in Ioana's reliance, but this is the one that we're talking about in this claim. All right, there's 2 other claims that I want to talk to you about. First is conversion. And conversion is the intentional exercise of dominion or control over property, which so seriously interferes with the right of another to control it that the actor may justly be required to pay the other the full value of the property. That's kind of a lot of words to say that somebody took your stuff. Somebody took your stuff. In this case, Zubair intentionally exercised dominion and control over the mothership, contrary to the 2020 agreement and the 2022 affirmation and ratification, interfering with Ioana's right to control the property. And further, he obtained a second mortgage in the amount of $115,000, encumbering the property against her wishes. In order for Ioana to be compensated fully for that conversion, she must be awarded sufficient damages to have that lien removed. The last claim, a breach of fiduciary duty by Zubair as trustee of Ioana's property. Trustee is someone who holds legal title. Their name's on the title, but it's for the benefit of somebody else. That is the very arrangement that existed here. Zubair was the legal title holder for Ioana's benefit to their 2020 agreement and 2022 affirmation. As a trustee, Zubair owed a special duty to Ioana called the fiduciary duty. While most transactions we enter into are considered arm's length, where each party is looking out for their own interests, in a fiduciary relationship, the trustee is required to act on a higher standard of care and use special skills or expertise, or act as a reasonable person in their situation in dealing with the other person's property. In this case, Zubair would have been required to put Ioana's interests ahead of his own in considering the actions taken with respect to the property. He breached that duty by taking a second mortgage on the property contrary to Ioana's wishes and without her knowledge and consent, that in no way benefited her or the property. Measure of damages on this claim includes lost money or other property, profit and proceeds that Ioana would have received as Zubair had performed his duty, and money or property that is unjust for Zubair to keep as a result of the breach. In particular, we're seeking sufficient damages to unencumber the mothership, plus a disgorgement of any investment proceeds Zubair may have gained through the investment of the second mortgage. The last thing I want to discuss is burden of proof. Now, if you've ever watched Law & Order, you've likely seen them discuss criminal burden of proof, which is beyond a reasonable doubt. We've already read about it today. That is a very high standard, and it's not applicable in this case. There are 2 standards at issue in this trial. The first is called preponderance of the evidence, which you heard the judge discuss already. Lawyers generally think of this as a 51% standard, more likely than not. That standard applies to breach of contract claims. The second standard, which you've seen, is clear and convincing evidence, which is something higher. How much higher is hard to say. I won't put a percentage to it, but it's higher. This standard applies to defendant's common law fraud claim. Regardless of which of these standards applies, as you consider the claims of the parties, we believe that Ioana has met her burden. We're asking you to find that pursuant to the 2017 roommate agreement, the $94,000 and its investment proceeds belonged to Ioana, that you deny all of Zubair's claims on that issue. We're also asking that you find, pursuant to the 2020 investment agreement, the mothership house located at the address we've seen many times on 22nd Way belongs to Ioana. We're also asking you to find that Zubair's second mortgage that now uncovers the property was not authorized or legally justified, and that Ioana is entitled to an award of damages in an amount sufficient to eliminate the lien created by it. Remember, according to Zubair's own testimony, the only logical owner of that property is Ioana. Thank you.
Each side has claims and they each get the last word on their claims. So we'll hear from Mr. Hannell and then Mr. Richardson will have a last word on defendant's claims.
No further argument, Your Honor, from plaintiff.
All right. Well, then let me read the remaining of the jury instructions and we'll also give you the verdict forms. Can I take a look at the verdict forms real quickly and make sure they're right? Okay. All good. Folks, this case is now submitted to you for decision. I'm reading the closing instruction. When you go to the jury room, you'll choose a foreperson to preside over your deliberations. You may discuss the case and deliberate only when all jurors are together in the jury room. Don't discuss the case with each other or anyone else during breaks. The admonition I gave you during trial remains in effect when all of you are not in the jury room deliberating. This is a typo. It says all 8 of you must agree on a verdict. That is not true. It's not a unanimous verdict. It should say 6. At least 6 of you must agree on a verdict. If all 8 agree, only the foreperson needs to initial on the line marked foreperson. If 6 or 7 agree, those who agree must initial the verdict on the numbered lines provided, leaving the line marked foreperson blank. Please write your juror number on the line next to your initials. You'll be given 6 forms of verdict. Sevilla is going to put them on the screen and I'll read them. There's no significance to the order. She's going to read them, but you'll have them with you in the jury room. Okay, verdict form number 1. That's good right there. On plaintiff Hussaini's breach of contract claim against defendant Sammartinian, we, the jury, duly impaneled and sworn in the above entitled action, find in favor of, and as a checkbox, find in favor of plaintiff or you find in favor of defendant. Next one, please. If you find in favor of plaintiff Hussaini on his claim against defendant Sammartinian, you must answer the following. We, the jury, and I'm going to sort of skip over the standard duly impaneled and sworn language, find plaintiff Hussaini's damages to be, and there's a line for damages. Number 3, on defendant Sammartinian's conversion claim against plaintiff Hussaini, we find in favor of, and you'll check 1, defendant or plaintiff. Number 4 follows the same pattern. On defendant Sammartinian's fraud claim against plaintiff Hussaini, we find in favor of, and a checkbox for either party. Number 5, on defendant Sammartinian's breach of fiduciary duty claim against plaintiff Hussaini, we find in favor of, and again, the same options to choose defendant or plaintiff. And then the damages verdict form for defendant is verdict 6. If you find in favor of defendant Sammartinian on her claim against plaintiff Hussaini, you must answer the following. We, the jury, find defendant's damages to be, and there's a blank line for damages. You will be also given 3 what we call special interrogatories, which are questions you must answer. They're all each yes or no questions. Special interrogatory A, did the parties mutually intend the 2017 residence agreement, plaintiff's exhibit 1, to be a binding contract? Yes or no? Special interrogatory B, did the parties mutually intend the roommate agreement, plaintiff's exhibit 2, and related promissory note, plaintiff's exhibit 4, to be a binding contract? Yes or no? C, did the parties mutually agree in 2020 that defendant Samartanian would retain her ownership of the property at 15824 North 22nd Way despite transferring title to plaintiff Hussaini? And you'll check yes or no. Thank you, Sophia. During deliberations, if you have a question for me or wish to communicate with me on any matter, use the jury question forms we'll provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I'll consider your question or note, and if necessary, I'll consult with the lawyers before answering it in writing. Don't tell anyone, including me or my staff, how you stand numerically or otherwise until after you've been discharged. Deliberations follow the same schedule as trial, from 9:30 a.m. to 4:30 p.m. Monday through Thursday until a verdict is reached, taking reasonable breaks as you deem appropriate. If all of you wish to deliberate earlier or later than this schedule, submit a written request. Once you've reached a verdict, notify the courtroom assistant and we'll bring you back into the courtroom to read the verdict. Counsel, anything we need to discuss at the bench before I excuse the jury to begin deliberating?
No, Your Honor.
No, Your Honor.
Thank you. The jury is excused to begin deliberating. We'll deal with it. Take the jury back and then come back. All right, be seated, please. My team has reminded me that I forgot to swear in Sevilla and Sierra officially, and so we'll do that after Sevilla has had a chance to settle the jury. That's a formality. We can take care of it. Let me talk about a couple logistic things. First of all, thank you all for your professionalism during this trial. I really appreciate it. And Mr. Richardson, I appreciate you coming in and handling the trial. I'm glad we're able to get it done, and I know that there were some last minute health things, so thank you. Stick around. We may get jury questions, and if I get a jury question, I need you either on the phone or here within 5 minutes to help answer that question. If we get a verdict, I need you within 10 minutes of being physically present in the courtroom so that we can take that verdict. After the verdict, we'll excuse the jury. It's often my practice to go thank the jury in person, and I've sometimes had lawyers that want to talk to the jury. Because of what else we have to do in this case, I don't think it's prudent to do it here. And so I'm not going to bring you back to talk to the jury, and I'm not going to talk to the jury. We'll thank them in the courtroom and send them on their way. The other thing I typically do at trial is when we're done, I'll set a deadline for attorney's fees motions and forms of judgment, but I'm not going to do that because we're going to set a schedule for getting the equitable claims resolved. Which brings me to my next point. I'm open to what you all want to do, whether that is briefs on those issues and/or proposed findings and conclusions. What do you think? I'll start with you, Mr. Richardson, since they're your equitable claims.
I prefer briefing and proposed findings.
Okay. Mr. Hannell, you okay with that?
Yes.
Yeah. So I will, I'll make the proposed findings and conclusions optional, and the briefs mandatory. And we'll just do simultaneous briefs on those claims. 2 weeks from today, okay?
Yes, Your Honor.
Your Honor, I'd ask for, can we get it 3 weeks? I have several conflicting depositions.
That's fine.
No objection, Your Honor.
That's fine. All right, let me look at the calendar. All right, so today is the 29th. 3 weeks puts us on the 19th. So I'll order that the parties file simultaneous briefs and optional proposed findings and conclusions no later than 5 p.m. on August 19, after which the court will deem the equitable claims under advisement and issue a ruling. That ruling will contain a deadline for final judgment and requests for fees and costs. Now, as you get close to the 19th, you all may decide to give each other extensions. I'm okay with that, but I want you to understand what it does because I'm out of town from August 28 to September 8. So if you extend that more than a day or two, it's going to push my decision out probably to the week of September 14. And to be honest, I'd rather not wait that long. I'd rather get you your decision and we can wrap this case up.
Understood.
Okay. Anything else y'all want to talk about?
Yeah, Your Honor.
Just to your comment regarding my recent participation, I appreciate the court's patience with me getting my feet under me for this case with the jury instructions. So thank you.
All right. We'll see you when we get a jury question or a verdict. Thank you.
Thank you, Your Honor.
If you do leave the courtroom, just make sure Sevilla can see or know how to get a hold of you. Actually, hold on. We're not going off the record. I need to do the swearing in. All right, we'll swear in you as officially bailiffs.
Do you swear that you will take charge of this jury and protect their deliberations from all outside interference and communication? And when we have reached the verdict, you will bring them back into court without revealing their verdict to anyone, so help you God?
All right, thank you. We'll be in recess.
Judge.
Thank you, Your Honor.